evening, distinguished guests, colleagues, ladies and gentlemen. I have to start with an apology. I'm a D lawyer, and speaking to a group full of people in a room like this scares the dickens out of me. So you'll have to bear with me as I stumble my way through my remarks. The only saving grace for me and for you is that we have two very distinguished orators who will follow me and therefore make this evening worth your while for having schlepped, at least in my case, in the rain to get here. On behalf of Jones Day, it is my pleasure to welcome you to the Jones Day Distinguished Visitor Lecture on Comparative Commercial Law. You have to try and say that 5 times really fast. Held in partnership with the National University of Singapore's Faculty of Law. Established in 2022, this lecture series reflects Jones Day's commitment to advancing thoughtful dialogue on comparative commercial law and fostering engagement between the judiciary, academia, and the profession across jurisdictions. This evening, we're especially honored to welcome our distinguished visitor, the Right Honourable Beverley McLachlin, former Chief Justice of the Supreme Court of Canada. I got that one right. As a fellow Canadian, I am truly privileged to be able to welcome Justice McLachlin to Singapore, my adopted home. She's one of Canada's most distinguished jurists whose life and career have shaped modern Canadian law and influenced courts and legal communities well beyond Canada. Over a remarkable career, Justice McLachlin became the first woman to serve as the Chief Justice of Canada, yay, and she held that office for 18 years, the longest tenure in Canadian history. Her judgments are widely admired for their intellectual rigor, accessibility, and principled balance between doctrine and lived reality. She has also been a steadfast advocate for judicial independence and for maintaining public confidence in the courts through reasoned and transparent decision-making, something we are all learning we cannot take for granted. Justice McLachlin's work is particularly fitting for this lecture, given her longstanding engagement with comparative perspectives. She has consistently recognized that while legal systems are rooted in legal context, common law jurisdictions face shared challenges, especially in commercial law, as markets globalize and legal issues increasingly transcend borders. Against that backdrop, this evening's lecture will explore the relationship between the rule of law and commercial dispute resolution. It will focus on the importance of clear, rule-based rights and obligations enforced through established legal processes. Consider how the historical foundations of commercial adjudication have shaped modern notions of legal certainty and judicial authority, and explain why a strong rule of law remains critical to economic activity in today's complex environment. We are also deeply honored to have with us our guest of honor, Chief Justice Sundaresh Menon, the Chief Justice of Singapore, who has kindly agreed to offer opening remarks. Known for his unwavering commitment to justice, integrity, and the rule of law, the Chief Justice has had a distinguished career marked by thoughtful leadership and significant contributions to the development of commercial law in Singapore and internationally. His participation tonight will undoubtedly enrich our discussion. I am so pleased that he's able to be our guest of honor today. Before we proceed, I'd like to thank our colleagues at NUS Law for their partnership and a collaboration in making this event possible, and to all of you for joining us. And with that, it is my great honor to invite the Chief Justice to the stage to deliver his opening remarks.
The Right Honourable Beverley McLachlin, former Chief Justice of the Supreme Court of Canada, Ms. Sushma Jobanputra, Partner in charge of the Singapore Office of Jones Day, Professor Hans Chio, Director of the E.W. Barker Centre for Law and Business, distinguished guests, ladies and gentlemen, friends. It's a pleasure for me to join you all this afternoon, including my former colleagues at Jones Day, to speak briefly on the rule of law, a subject of profound importance to Singapore. This year marks the bicentennial of Singapore's legal system, commemorating 200 years since the promulgation of the Second Charter of Justice that established our court system and indeed our legal system. This milestone offers us a timely opportunity to reflect on the central role that the rule of law has played in shaping Singapore's development over the course of the past 2 centuries. I'm therefore especially delighted that we will hear today from my good friend and esteemed colleague, the former Chief Justice of Canada, Beverley McLachlin, who will address the importance of the rule of law, its relationship with commercial dispute resolution, and the challenges that are confronting it in our time. In the time that I have, let me offer a very brief Singaporean perspective on some of these themes. Prior to the arrival of the Second Charter, Singapore was, as our colleague Justice Andrew Pang has observed, in a state of legal chaos. There was no coherent framework for securing law and order. This was plainly unsatisfactory given Singapore's role as a British trading port and a strategic entrepot along the India-China trade route. The absence of a structured legal system and uniform laws did little to inspire confidence among merchants that disputes would be resolved predictably or in accordance with established legal principles. This changed with the promulgation of the Second Charter of Justice in 1826. The Charter established a court of judicature to serve the Prince of Wales Island, now Penang, Singapore, and Malacca. Although it didn't expressly provide for the application of English law, the provision requiring the court to give judgment according to justice and right was interpreted as mandating the application of English law as it stood in 1826. This was subsequently complemented by Section 5 of the Civil Law Act, which provided for the continued reception of English commercial law after that date. And that provision has since been repealed and replaced by the application of English Law Act 1993, which clarified and rationalized the position on the application of English law in Singapore. The significance of English law to our own commercial development cannot be overstated. As early as 1871, Chinese merchants in Singapore publicly praised the Chief Justice, Maxwell, for promoting the prosperity of the port by faithfully upholding English law. And more recently, Chief Justice Yong Pang Hao observed that because Singapore had inherited a system of law which is familiar to most, our laws are readily ascertainable, and contractual and proprietary rights are recognized and given binding legal effect. But the impact of the rule of law in Singapore extends well beyond commerce. Domestically, it has been instrumental in maintaining law and order, fostering harmony and social cohesion in a diverse society, particularly in our formative years when racial tensions were at times acute. And internationally, we have consistently maintained that the rule of law is vital to the survival of small states like Singapore by enabling all states, large and small, to engage with one another peacefully within a stable and predictable framework. And that's an imperative that is more important now than ever. It is therefore imperative that even as the rule of law comes under increasing strain, we continue to affirm it. As I've said elsewhere, we cannot afford to succumb to despair. The responsibility lies squarely with all of us to defend, restore, and revitalize the rules-based order that we have inherited. And it is therefore a particular privilege to have Beverley with us today to speak to us on these issues, and I look forward, together with all of you, to learning from her insights. Sushma has spoken about Beverley's history, but let me just share a little bit more. She earned her BA in philosophy in 1965 and an MA in philosophy and LLB in 1968 from the University of Alberta, and was then called to the Alberta and British Columbia bars, where she practiced law and taught at the University of British Columbia's Faculty of Law for about 7 years. Her judicial career, which is probably the defining aspect of her professional life, began in 1981 with appointments to the Vancouver County Court. And I mention that because of the speed with which it proceeded from there. She was very rapidly elevated to the Supreme Court of British Columbia, then to the British Columbia Court of Appeal in 1985, and then as Chief Justice of the Supreme Court of British Columbia in 1988. She was appointed to the Supreme Court of Canada a year later in 1989, and then made history in 2000 when, as you heard, she became Canada's first female Chief Justice. And over the course of the next 18 years, she played an instrumental role as a highly effective, and I say this advisedly, a universally admired and respected Chief Justice of her country. Lady Hale, the former president of the Supreme Court of the UK, observed that Beverley's decisions spanning domains as diverse as proportionality in judicial review, illegality in contract, tort and restitution claims, unjust enrichment, equitable compensation, and vicarious liability have not only shaped significant aspects of Canadian law, but have also resonated across common law jurisdictions. But Beverley's legacy extends beyond her jurisprudence. Under her leadership, the Supreme Court of Canada cultivated a stronger culture of collegiality. Unanimous judgments became more frequent, and when the court did divide, there were fewer separate dissents. And this reflected a leadership style grounded in careful engagement and mutual respect. When Beverley retired from the Canadian Supreme Court in 2017, I was among the early people to knock at her door, and I was delighted and tremendously honored when she accepted the invitation to join us in Singapore as an international judge of the Singapore International Commercial Court. And I've since had the absolute privilege of sitting with her and hearing matters together. And the perspectives that Beverley has brought to our deliberations have always been nuanced and insightful and enriched our discussions in a manner that reflect both her depth of experience and her tremendous intellect. So it is my great pleasure now to ask Beverley to deliver her lecture. Please join me in welcoming her.
Good evening, everyone. Thank you for coming out and being here with us tonight. It's really a very great pleasure to be here with you. Thank you, Sushma. Thank you, Sundaresh, Chief Justice of Singapore, for those very generous remarks. I'm deeply grateful. And I count, as I said to someone just a few moments ago, your Chief Justice as among my most admired Chief Justices in the world. So it's lovely to have him grace us with his presence tonight. It is indeed a great honor to be invited to give this lecture. I first visited Singapore in 2000. I had been barely sworn in as the Chief Justice of the Supreme Court of Canada when I received an invitation from the then Chief Justice, Yong Pung Hao, of Singapore to give an annual lecture. I believe it was called the Hochelaga lecture. Well, of course, I accepted with alacrity. And my husband and I came to Singapore. Veni, vidi, vici. We came, we saw, we didn't quite conquer, but I can say that Singapore conquered us. My husband and I fell in love with Singapore, its physical beauty, its warm hospitality, and not least, its vibrant legal culture. That was 26 years ago, almost to the day. And Singapore still evokes the same admiration. In a world of shifting values, Singapore has stood firm for the rule of law and fair and just dispute resolution. Indeed, its judicial reach has grown with the establishment of the Singapore International Commercial Court, on which I'm proud to sit. And also, we will note, I think in November of this year, as the Chief Justice said, the 200th anniversary of modern justice in Singapore. Modern may be a stretch, but the fact that justice has been prized and treasured here for 200 years is a very important thing to note. It goes without saying, therefore, that I was, as you've heard, delighted to join the Singapore International Commercial Court, and equally, it goes without saying I'm delighted to have the honor of delivering this lecture. Tonight, I would like to share some thoughts on the rule of law and how we can maintain it in the tumultuous times in which we are living, and the relationship of that quest of commercial international law to maintaining the rule of law. My goal isn't to offer solutions, I'm too humble for that, to the many challenges the rule of law is facing in the world today. It's rather to offer a few thoughts from the perspective of a person who spent over 6 decades working with and thinking about the rule of law and its role in preserving a peaceable and prosperous world. Thoughts that I hope may stimulate you to develop your own views and to craft your own solutions. Every society is different, and what works in one country may not work in another. We must all find our own path, but the values and the dynamics that shape that path transcend national boundaries. And that's why we talk about influence between nations and international law. The values that underlie the different manifestations in different countries are prime. Now to the rule of law. I have to define, of necessity, what I'm going to talk about. As you know, different people hold different definitions of the rule of law, and I'm not going to be seeking today to try to describe different conceptions of the rule of law. For the purpose of this lecture, I'm going to use the term rule of law in the basic sense of a rule-based legal order comprised of 3 elements. 1, law made in accordance with the Constitution in a legally valid manner. 2, independent and effective adjudication to resolve disputes. And 3, effective and impartial enforcement of judicial orders. Those 3 elements are absolutely critical to any country that wants to say it possesses the rule of law, I believe. And they are critical, you might observe, to a good, well-functioning commercial law system. I have structured my remarks as a series of propositions, only 4, so don't be too frightened. I hope you will bear with me as I work my way through them toward the ultimate question: how best can we preserve and build a world based on the values and principles of the rule of law in these perilous times? My first proposition is that we are facing great challenges today in maintaining the rule of law. We are indeed living in perilous times. In many parts of the world, the rule of law is being diminished, and in some, it is unraveling. The rule of law, in the sense we understand today, was ushered in by changes in the world alignment after the Great Wars. The First and Second World Wars, which some view as one continuous war with a decade-long pause between, brought about a monumental shift in geopolitical alignments and governance throughout the entire world. The old order of absolute rulers who viewed themselves as able to make the law and as actually being the embodiment of the law was swept away, and a new order was put in its place. Geopolitically, the world divided itself into new blocks, what we call the Western USA-led bloc with Europe, North America, and so on, and the Soviet Union bloc dominated by Russia. But that's only half the story, because great changes were happening in the rest of the world. China had its own communist revolution. India established itself as a sovereign nation. Various African and Asian countries found different ways forward as they navigated the conflicting currents of democracy and communism. One thing was clear, however: the old order had unraveled and would never come again. Absolute rulers were out. New ways of ordering society were in. The fragile internationalism was a hallmark of the New World Order that came in after the Second World War. The fragile League of Nations was out, and United Nations, with its expansive declarations of human rights and economic and social development, was in. New world economic institutions were created: the World Bank, the FAO, many others. And international law and international courts were made. For example, the United Nations-based International Courts of Justice. It was a time of heady hope and promise for those of us, I wasn't very big then, but for people who came to understand and care about the rule of law, and which was underlying all of these assumptions and developments. Never again, the world said, will we let tyrants wreak injustice. Law and law-based institutions will save us from future injustices and will promote economic growth and human flourishing hitherto unknown. That was how it looked in the 60s and on. And it worked most places for a while. With some notable exceptions, the world generally became more prosperous, more peaceful, and for a time, more democratic. New rules were drafted to meet new situations, and disputes, whether domestic or international, were increasingly resolved by legal process in the courts or by rule-based arbitration tied to legal processes in courts. After the fall of the Berlin Wall in 80, and the embrace of democracy by the former Soviet Union countries, historian Francis Fukuyama famously declared the end of history. Well, except that history kept rolling on. At the beginning of the 21st century, the orders that had dominated the world since the Second World War started unraveling, so subtly that at first we didn't notice it. In 2011, not too long ago, Democracy Watch reported that the democracy curve that had steadily been rising, you can check this out, it's online, had peaked and was now on a downward trend, and it's been there ever since. Human rights monitors reported similar declines. Democratic countries slipped toward autocracy, and the World Justice Group reported that indicators of the rule of law were dipping in many countries around the world. The unraveling of the post-war rule-based institutions that brought us peace and prosperity over the past decades, almost 8 decades, is now continuing. In many cases, it seems to be speeding up, and in some cases, actually failing. The sovereignty of countries is increasingly being challenged or ignored by strong men who want their way. Courts are increasingly weakened by leaders who hollow out the court's jurisdiction and refuse or delay in enforcing their orders. People, even in mature democracies, are rounded up and sometimes sent to prisons abroad and even killed without due process. All this is happening in at least one prominent democracy. Arbitrary edicts are increasingly replacing law-based rulings. So this is the challenge. We are living in a time when the rule-based order created after the Great Wars is unraveling in many parts of the world. The rule of law, which supported personal security and economic growth for so many years, is in many areas in peril. The challenge that we face is to maintain it through the rocky shoals we are now navigating and bring it intact into the future. My second proposition is that the weakening of the rule of law should not be normalized as inevitable or right. I've seen this happening by many scholars and analysts, and I feel it is a very negative development. It's possible to put up various arguments against the rule of law. Legal processes take too long. Unelected judges are handed the power to make orders of great consequence, yet are accountable to no one. Court orders interfere with the right and ability of political leaders to do what they need to do in a rapidly changing world. And finally, what's the big deal? Nations have always acted in self-interest. Requiring them to curb those interests by legal norms and courts is like Don Quixote tilting at windmills. Fun in the short term, but futile in the long term. Those are some of the arguments that are put forward. I, for one, do not accept them. The first argument is that rule-based decision-making takes too long. It's cumbersome, it's slow. Sadly, I have to say that this is sometimes the case. It is in my country. But the answer, it seems to me, is not to reject rule-based decision-making, but to make it better, eliminate delay. We need fast, efficient courts as we enter the second quarter of the 21st century. With the possible exception of Singapore, many of our courts have been neither quick nor agile in adapting our legal processes to the ever-increasing pace of the 21st century world. If we want the rule of law to survive, we must do better. But remember this basic proposition. You don't throw a good thing out because you fix it. In this age of the internet and AI, I can and think we should do better. We should be using algorithms to make our courts run better. Scheduling, effective allotment of resources, prompt delivery of orders and judgments come to mind. I do not believe that AI will ever be able to replace human judges in resolving human disputes. The problems human beings throw up for resolution are too varied and complex to provide just solutions on an algorithmic basis. And where is the trust that people must have in the courts? They can trust a group of people who are devoted to maintaining clearly articulated principles. But will they trust an algorithm? Will they trust a machine whose processes they don't understand? But that said, I believe we need to use all the tools available to bring our justice systems firmly into the 21st century, to make our courts more responsive and more efficient. Now, that was the first argument. Courts don't work very well. The second argument is a more theoretical one. Unelected judges lack the institutional legitimacy and accountability to make decisions. They answer to no one. There's no check on their powers. They may be woefully out of touch, and so on and so forth. The list of complaints goes on. The answer to this argument goes back to the conflict between King James I and Lord Coke in the 16th century. The king, in an era of divine right of monarchs, maintained that he, under God's direction, made the laws, and that judges had no power to tell him what to do. He was the emanation from God of justice and the law. Coke answered, and he lost his position and almost his life for doing it, that the law was supreme, even over the sovereign. Coke's view has prevailed in England and most democracies for 4 centuries, and for one reason, it has worked very well. Regrettably, I have to note at this point that last year the Supreme Court of the United States ruled that the president cannot be held accountable for official acts. I view that personally as a derogation from the fundamental values that uphold the rule of law, and regret it. I hope someday it will be changed. And the reason that Coke's assertion that judges and courts, not rulers, make the law, has worked is that they've had independent judges, impartial judges, learned judges who did a much better job than any single dictator could do. And the traditions of the law, which you all know about and use every day, have been preserved through that system of independent, impartial judges. The third argument against the rule of law is that rules and courts should not be able to interfere with political leaders because strong, swift action is required to meet the challenges of our complex modern world. Things have changed, things move fast, things are complicated. How can the serene pace of judicial deliberation be up to the job? And so, the argument goes, the executive power should not be constrained by judges, or the nation will suffer and fall. I believe this argument to be a red herring. Almost all modern constitutions contain emergency power exceptions that allow prime ministers and presidents to take swift action when it's needed. But if swift action is not manifestly and clearly required, the rule of law should be maintained. History is replete with examples of presidential edicts made in haste with disastrous consequences for the people affected and the future of their nations. The fourth and final argument is the argument of inevitability, and in some ways it's the most dangerous. Countries and the people, usually men, who lead them, have always and will always act in self-interest, the argument goes. This is natural and normal. Leaders can't be expected to be constrained by petty rules, even if those rules claim to be law. The law is a tool, certainly, but it's a tool that the leaders get to use or cast aside as they wish. This is how it has always been, the argument goes, and always will be. As Bismarck taught when he invented the term realpolitik, principles, and by extension the legal order that enforces them, are nice for decoration, but aren't up to the heavy lifting required for self-governance. Self-interest is the only real driver of governance. This argument is based on history, except, I believe, it gets history wrong. It ignores the centuries-old fact that countries can and do make rules that bind their leaders to keep their power in check and temper basic self-interest. These rules are called constitutions, or sometimes conventions of a constitutional nature, as in England. But the best answer to this argument, in my view, is that it actually sets up a false dichotomy between nations acting in self-interest on the one hand and the rule of law on the other. I believe the two ideas are not incompatible. In fact, they complement each other. Nations can and do act in their own interests as they perceive them. That is obvious. But ideally, they pursue those interests within the legal framework of their constitutions, conventions, and commitments. To do otherwise would be to revert to the law of the jungle, brute force, unpredictability. Viewed thus, the fact that nations act in self-interest does not support the inference that rule-based governance should be jettisoned. As it turns out, acting in a rule-based, principled manner is almost always consistent with the best interests of a country in the long run. Acting arbitrarily in violation of legal norms is almost always bad for the country in the long run. Even if one concedes that in times of emergency, swift action is required, as a general rule, best interest and the rule of law are not in conflict, but rather support each other. A brief analogy to commercial activity may assist. Businesses, large and small, act in their own self-interest. I'm sure you'd all agree with that. But we don't take that to mean that the rules that guide commerce and the courts that administer those rules should be thrown out. Rather, the rules are the instruments through which commercial self-interest is channeled and realized. Self-interest is a crude cipher that doesn't work if you need something from somebody else. You must concede and cooperate to get what you and your self-interest want. And that brings in legal rules and norms. In sum, self-interest and legal norms are not binary concepts in polar opposition. Rather, they are both vital. So I've spoken of 4 arguments that are put forward against maintaining a strong rule-based system of governance and the rule of law. There are many others probably that I haven't dealt with, but let me simply say this. The case that the rule of law is not fit for purpose in the 21st century remains to be made, at least for me. It follows that we should do all in our power to preserve the rule of law, as the Chief Justice has said, for our times and for future generations. My third proposition is that we can support the rule of law through these difficult times by maintaining and strengthening commercial law and commercial dispute resolution processes. We sometimes forget that much of our modern conception of the rule of law developed from humble beginnings in English contract and commercial law. England secured an empire in the 17th, 18th, and 19th centuries, and we attribute this often to wars and diplomacy. But what sustained the empire through the latter part of its time was the rule of law. It was the English law. In the 19th century and on into the 20th, English courts built up a formidable body of commercial law. The world had never seen its like. Underlying this, and also I add maritime law, naval law. Underlying this was the view that principles should guide commerce and shipping and should be developed and supervised by the courts, and that commercial disputes should be resolved not by force, but by legal process. This idea spread throughout the world in an empire where the sun never set. Singapore, whose 200th judicial anniversary we celebrate this year, was one of the beneficiaries of the process. The spread of commercial and maritime law throughout the world in turn produced the idea that law, until then very much a national matter, could and should have international force. We often think of the Treaty of Westphalia, which set down the rules of sovereignty in war after the 100-Year Wars, in which half the population of Europe died, as the beginning of international law. But the application of the British commercial and naval law played an equally vital role in the acceptance and development of international legal norms on the civil side. Having set out this thesis, allow me to take a step back and examine the origins of the rule of law in the commercial world. Sociologists and archaeologists tell us that the earliest emanation of commerce was a barter system. No rules, no contracts, no need for enforcement. Didn't need judges then. Just a simple exchange. If the product was deficient, too bad. There were sorts of norms and laws that were applied by tribal leaders and so on, but it was always a very simple matter. Barter wasn't sufficient to serve the needs of trade as it continued to develop. So the ancient world introduced the notion of contracts, judges to rule on disputes and enforcement backed up by the state. In short, a rule-based legal system. Roman law refined and perfected the rules and methods of adjudication. A millennium later, after what some have called the Dark Ages, European countries resurrected these ideas and called them Roman law. They persist to this date. And it is now generally accepted that for commerce to flourish, there must be a system of enforceable and enforced norms. The rule of law is one way to enforce and maintain norms. I believe the best way. But it's interesting to ask, what happens if you don't have a rule of law? This happened in what is now Italy. For long centuries, Italy just consisted of small states, and they were ruled by petty princes, often living somewhere else. There was very little interest in good governance. There was indeed neglect, benign neglect. The princes would appoint agents who did or did not enforce or make rules. Scholar Luigi Barzini describes how the Italian people in these circumstances, where there was no central rule of law, no enforceable state enforcement of rules, turned to other ways of finding enough certainty to do business and build infrastructure. Instead of a system based on valid legal laws emanating from valid authorities, independent courts, and state enforcement of edicts, the three principles I have cited as being at the heart of the rule of law, they resorted to family structures, these little states, networks of clans and associates bound by oaths and codes of honor, who could be counted on to honor their own promises and ensure that the promises of others were kept. These powerful families or clans used carefully calculated violence, and sometimes not so carefully, to enforce obligations. You see what I'm getting at? We still have some of this today in our world. The family system of commercial obligation and enforcement persists. I'm not a scholar of Chinese law, but I understand that historically in China, relationships, the family, have played a big role in how people got their commercial dealings enforced. And in the United States and parts of Canada, I have to admit, it still persists. at the edges, the gray edges of the law where the rule of law is not really being enforced, such as drug dealing and other illegal activity. It's actually founded a literary genre, culminating in the movie The Godfather. But as I say, in most modern countries, families operate in the gray area where the state doesn't go. I've digressed into the lore of the underworld to make a simple point. Commerce, legal or illegal, requires both rules and enforcement, and it's going to happen one way or the other, or you don't do business. Where the rule of law is strong, the space for underground rulemaking and enforcement is small. Where the rule of law is weak, the space for illicit activity and corruption is vast. The takeaway is this: if we want vibrant, creative commerce, if we want to build infrastructure without bribes, if we want to encourage new products, new investment, new commercial creative activity, we need law, supported and sanctioned by the state and delivered by impartial adjudicators. For a long time, commercial law was the domain of the domestic courts, but as international commerce grew, new forms of commercial rulemaking and adjudication emerged to meet the needs of the global economy. Parties to international agreements chose the law that would govern their dealings, put it in their contracts, in effect taking national law and converting it into international law for their private purposes. Legislation, domestic and international, recognized arbitration as a legitimate form of commercial dispute resolution, and arbitral institutions arose in USA, Europe, Middle East, and other venues to facilitate dispute resolution in the international context, all under the supervision, certainly when jurisdiction was concerned and fundamental principles of law, of the courts. The internationalization of commercial law in the 20th and 21st centuries, supplemented by investor state law, has proved a great success. Some grumble that arbitration sometimes takes too long, that appeals from it are limited to jurisdictional and pure law points, and that it can be expensive. And they point out that because arbitration is private, it does not serve to develop the law in the way precedent does in the courts. And all that's true. But despite these shortcomings, international arbitration continues to flourish. The latest development in the story of the rule of law in commerce is the creation of international commercial courts, which apply court rules and publish precedents, which are open to the public and transparent. Singapore took a place in the forefront of this development with the creation of the SICC, which is increasingly recognized and respected throughout the world. But I don't need to tell this audience about that. Courts in other places have followed suit. We now have international commercial courts in Dubai, Qatar, I believe Kyrgyzstan, India, and more. And in many ways, the commercial court in London serves as an international court where disputes from around the world are being supervised and heard. But let me get back to my point. In a world where domestic courts are being shunted aside, emasculated, and undermined, international rule-based contract creation and commercial adjudication is thriving. Why? Because the commercial world needs it. Rule of law-based institutions are providing the certainty, structure, and enforcement that international commerce and development requires. There is a powerful pragmatic explanation for why the rule of law continues to flourish in the commercial world. Economic prosperity and growth depends on the rule of law to provide certainty to investors and justice when things go wrong. Those countries with a strong rule of law will inevitably outperform those who do not have it. I earlier spoke of how the domestic commercial law and naval law of England spread around the world, reinforcing the principle of rule-based justice we call the rule of law. The examples of international commercial law I've been describing, arbitration and international commercial courts, can play the same role in our modern interconnected world. This stands, I believe, as a potent refutation of those who decry the utility of rules and the rule of law. If the rule of law works in the world of commerce, it can and should guide other areas of human endeavor. When we finally emerge from the miasma of negativism and absolutism and the raw exercise of pure power that some parts of the world are living through now, and we will, the culture of the rule of law and the international commercial world has embraced in recent years will be there, strong and vibrant, to lead the way back where the rule of law has been undermined. And that is a good thing. We can debate whether the old order will ever come back, whether it's even gone. That's a debate that is currently occupying the front pages of some of our papers and the speeches in Davos. I, for one, hope that the old order is not entirely gone and that what we're going through is a bad period and people will wake up and restore the good things we have been doing under the umbrella of the rule of law for the past 80 years. But whatever the case, whether we're going into a new order or whether we're going to have to just repair and improve the old order, we need the rule of law. I come then to my fourth proposition, and that's we need it in another way, to find solutions to the issues raised by technology, the internet, artificial intelligence. I'm not a techie, nor am I qualified to pronounce on the potential of artificial intelligence to wreak havoc in the world, as some have forecast. I can only say that together with the many benefits these technologies bring, the changes wrought by IT and AI will inevitably produce, and indeed they have already produced, profound and complex problems and disputes which need to be resolved. We need to put order in the international world of internet and AI. This is a huge challenge. Where do we draw the lines on privacy and pornography? Who is responsible for offensive online conduct, damaging conduct, conduct that can even kill? Complex, difficult problems that go to the heart of who we are as human beings. These are the problems we face. We have yet to bring online activities under the umbrella of the rule of law. The consequence is that people are injured without recourse to justice, and bad actors carry on with impunity. There may also be consequences, and I say this carefully, for the world of commercial activity. The problems raised by modern technology cannot be resolved on an ad hoc basis. They call for legal analysis and cooperation of an order of magnitude the law has not seen before. They need to be principled. We need smart laws, we need principled laws, and we need some form of international enforcement. Will we ever be able to resolve all the problems the emerging world of technology will throw up? Perhaps not. But as we speak, courts and tribunals are grappling with problems from cryptocurrency fraud to AI identity theft. It's a start. But think back when they started developing the principles of commercial law in England, before we knew what a contract was or what the requirements were. That was a start too, and I think we should make the start in AI. If the world ever needed the rule of law and the commitment to justice it stands for, it is now. Let me conclude. I promise to conclude with a few thoughts on how we can preserve the rule of law for the future. It's a tall order, but let me offer some ideas. Number one, we should be clear in our thinking about the rule of law and unapologetic about the benefits it brings to the world. We should not succumb to rhetoric that seeks to downplay or relativize the importance of the rule of law. Number two, we should work with people who share the values that underlie the rule of law to make our legal institutions, the legal profession, the courts, the arbitrators and adjudicators of all strikes, strong and effective. In our fast world, justice must be fast. We must provide citizens with access to justice in real time at affordable cost. We must be nimble and agile, developing effective solutions to the problems that arise. Number three, We should craft solutions to the new problems of the internet and artificial intelligence. We do not need to understand every technical nuance, but we need to be smart and work with people who are smart. Doing justice in the 21st century will involve high-level lawyering, judging, and enforcement. When old institutions, and this is number 4, are not up to the job, we should improve them or invent new ones capable of delivering what is required. This is what happened in Singapore under the guidance of Chief Justice Menon in creating the Singapore International Commercial Court. In our fast-changing times, we cannot rest on it's always been working, so we won't change it. We have to look ahead and find what is required for the new world in which we're living. Innovation and excellence must be our watchwords. These are but some of the ways we can keep the rule of law strong and carry it into the future. You doubtless have other and better ideas. So let's share our ideas. Let's work with others who share our values to implement those ideas. And above all, let us not allow the rule of law, which has given us so much, to slowly fade away. I thank you for your attention.
Floor is open for questions.
I'm happy to open this up, but I'm not going to ask a question. I'm actually going to speak in support of what Chief Justice McLachlin has said, because there's so much that she said that I agree with. And I particularly wanted to add to the part of your discussion on the 4th point, where you talked about the importance of the rule of law and dealing with some of the oncoming challenges that we're going to face. And I wanted to add one more to the list of issues that the world is facing. You mentioned technology, you mentioned AI, which I think are very, very important issues. The question of data and the question of who owns the data and how we regulate it. But there's also another huge issue that the world faces, which we really need the rule of law in order to work on the development of solutions, and that's the whole question of climate. And I think the point I would make is that if you look at some of the existential issues that are arising in the world today, the common feature about them is that they are issues that attack or threaten all of humanity. And they're issues that no one jurisdiction can come up with solutions to. No one jurisdiction can come up with solutions to the question of how you deal with technology or data or privacy or the degradation of truth in society. No one jurisdiction can come up with solutions to the problem of climate change. And it's a real frightening proposition in my view that if we allow the rule of law to devalue, we cease to have a platform upon which we can collaboratively come up with possible solutions and possible responses to this, because that is the need of the moment. The need of the moment is actually multilateral, collaborative responses to some of these issues because they threaten all of humanity. And it's very worrying that there is a growing narrative that suggests that the rule of law is not important or that it even doesn't exist, that it's just a nice thing, especially in international relations. My view, and speaking in support again of what you've said, my view is that if we allow the rule of law to degrade and to cease to be relevant, the only consequence where it ends will be war. And we saw that in the 1930s and 40s. We saw that. And it was the horror of what humanity saw in 1945 that brought the leaders of the world together to say never again. And I rather fear that we've forgotten how horrible the consequences were. And that's why I think we're starting to see intercurrency, this kind of narrative that suggests that law is not a reality, or it's not something that really needs to constrain nation states. I don't believe that, and I think that all of us as lawyers have a particular responsibility, I think, to reject that notion loudly and persistently for the sake of humanity and for the sake of future generations. So I don't have a question. I don't disagree with a word you said, but I passionately support what you said.
I thank you for that, Chief Justice. I entirely agree that in this global world, we've got to have a global international rule of law, and I also agree, and this was sort of my underlying burden, that we cannot allow the rule of law to be relativized, fade away. So many people have said to me in the last few weeks, it doesn't matter. It's just something you can use if you want to use. Those attitudes frighten me very badly because I believe that it will lead, as you say, to war, to terrible consequences. So thank you for that.
Good afternoon, Justice McLachlin. Thank you very much for your time spent sharing with us about your thoughts on the rule of law. I thought it was very meaningful and a good reminder of the importance of what we have today. I have two questions which touch on the points you mentioned in your lecture. The first is that you started by talking about how one key part of the rule of law was law created through processes that we trust.
Yes.
And I do think that the crisis that a lot of different nations are facing these days, and even in commercial dispute resolution, is a lack of trust in the process. There are countries where you feel that the lobbyists or big money has taken over the legislative process. Even on the dispute resolution part, sometimes it looks like litigation or arbitration is just an arms race. It's who has the most money, and that's how the common law is created. So I wanted to ask about your thoughts on how that trust can be rebuilt again.
Yeah.
The second question, unless you wanted to go.
I'll let you ask the second one later. At my age, I don't always remember questions, but forgive me. But you've raised the question of transparency, corruption, lack of rules in many parts of the world. And this is indeed a great problem. But I always like to see the glass as half full. What's happening is that nations who don't believe in rule of law, don't believe in principles, have to do business, have to build infrastructure. And when they do that, they run into dispute resolution issues. And what happens then? They find themselves under arbitration or under an international court. And so they get dragged into the rule of law machinery. And they learn, one would hope. Because if they don't pay the judgment of the arbitral panel for their negligence in relation to a big infrastructure project, they won't get anybody else to build infrastructure in their country. So it's kind of a slow process, and you can point to a lot of bad things. I'm very sorry to hear you say that you feel some arbitrations are dominated by money. I arbitrate. It's certainly, don't nominate me if you want me to take that approach. But, and I haven't seen it, but I believe that in some countries it can exist. But we have to make it better. We just have to broaden the reach, and we will. And that's why I say I think that the commercial world can educate people about the rule of law. Countries that never want to think about the rule of law have to think about the rule of law. And the people who lead them have to think about it. And they have to get smarter, or they won't go anywhere in the world. So we have a process of gradual, I think, education going on. Transparency International, it was interesting. They put out figures, and the World Justice Institute, I think, also confirmed this. They put out figures on rule of law. And those indexes, the rule of law index went down globally in all, they have about 25 headings that they look at. It went down, I think, on almost all 25 except for one, and that was corruption. So I'm not sure we're losing the war on corruption. I'm not sure we're going backwards. I'd like to make you feel happy and tell you that maybe we're making a bit of progress.
Thank you. And that actually sort of segues into my second question, which,
Yes.
again, just to hammer the point that I am somewhat pessimistic about it. On your third point about commercial dispute resolution, I was thinking of the string of Russia-related cases that came up, the anti-suit injunctions, the anti-suit
Oh, yes.
injunctions, enforcement
Right.
injunctions. It made me think about how, in the world, you talk about, even on the commercial front, one bad actor or one country that's not willing to play by the rules can, if powerful enough, try to step outside of the system. And I think as you talked about all the challenges of AI, of technology, as Chief mentioned about climate change, if there is one country that is powerful enough to ignore it, it seems quite hard for smaller countries like Singapore to resist
Right.
the pull of what's happening. I just wanted your thoughts on that.
Well, everything you say is true. And I was shocked to learn about anti-suit and anti-enforcement injunctions just last week at our injunctions at our conference, because it wasn't part of the world I had my law career in. But I can see how some of the ridiculous situations that are created may call for it, and fraudulent situations and so on. And all we can do is work with this. We can't make it get better. We can't change it. And it's so easy to get discouraged and say, well, we can't do anything. But I think if we do that, we just give in, and things will only get worse. And we have to maintain those principles, as I said ad nauseum, that underlie the rule of law. We may be going through a bad time. It may get better. We've got to try and do what we can to keep it on the right track and to keep those principles alive. Yes, many countries are unjust. And of course, it makes you feel very, very sad and sometimes impotent. But we shouldn't throw out what's good and what works just because some people have other practices.
First thing I do every morning is read the paper, and it's become so depressing. And I actually am still old-fashioned that, yes, I look at my social feed, but that I actually read the paper. But I would say there are two things that have happened that give me some hope. One is that I grew up in the same country as Justice McLachlin, and for many, many years, at least all of my adult life, the French part of Canada has always thought very differently, for the most part, to the English-speaking Canadians. But when we saw what was happening in the world around us and our elections were coming up, there was a massive shift in the way Canadians as a whole thought. And we set aside our differences and elected a prime minister that we thought could handle the turbulent times that we saw coming, not just globally, but specifically for Canada, because it was so dependent on its neighboring countries, being one. And so that gave me some hope that, as the Chief Justice is saying, when powerful nations behave in a way that we're not accustomed to seeing, it allows other nations to form relationships, as we're seeing happen around the world, to come together to be able to find a way forward to continue to respect the rule of law, in part out of self-interest, to be able to continue to do trade. So I would say that that's a little hope that I got last year through the Canadian elections, and it was probably the one time in my entire kind of career that I've thought that the Canadians were able to come together. It was a massive shift, and I'm happy to talk to you more about that. The second thing that I think is interesting is that 70 years ago, if you told anyone that Singapore was going to be rated in the top 3 countries in the world where people believe that there's a functioning legal system, trust the system, and international players would choose to have Singapore as the place where they would resolve their disputes, I think you would have been laughed out of the room. And it's a test, and so when you say small nations like ours, and we Canadians, we have a lot of land, but we're a pretty small nation, we know that. I think that Singapore is a fantastic example of how small nations can use the rule of law to make a place for themselves where people can come to transact business or to have their disputes resolved, knowing that they're going to get a fair hearing, and knowing that they can't buy the conclusion that they want. So I have to look for hope in this otherwise pretty dark period of our collective legal careers. And so I think that I think not all is lost. I think there's some hope.
If I can just add a footnote to that, 2 days ago, Prime Minister Carney gave a speech at Davos, and he took your point. I think he didn't know about you, but it's the same point. But he said that the small and medium powers of the world have to get together and preserve, because we're still very, very numerous. If you look at the people in Europe, Western and Eastern Europe together, they have a lot more force than Russia does, a lot more economic force, and maybe the military isn't as strong, but there's huge power in coalitions of small and middle powers. So this is where we can band together, and I talked about preserving the values, and we're not as weak as we think we are.
Well, I think if there are no more questions, that's probably a wonderful place to thank you, Justice McLachlin, for being the distinguished guest lecturer, and we're so thrilled to have you here. And I'm personally pleased to have met at least one of my heroes from Canada. So thank you very much.
Thank you.